think we are back in business. It's a little blurry, though. Oh, back in business. All right, I think we're good. Oh, all right, I think we're good. Okay. All right, let me. All right, Mr. Court Reporter, ready to go? All right, we are back on the record after some technical difficulties on our side. Okay, I think we're good. Mr. Miller's done.
Yep.
Mr. Albert, your exhibits. Mr. Albert, your exhibits. Try this again. Mr. Albert?
Yes, I have exhibits. We would ask, Your Honor, the two exhibits you've marked as Staff Exhibit 11, which was the bulk water filing, and Confidential Exhibit 12 be admitted into the record.
All right. Any objections on Staff 11 and 12?
No objection.
No objection, Your Honor.
All right. Hearing none, they're admitted.
Thank you, Your Honor.
May I raise some point?
Oh, go ahead, Mr. Tibbetts.
Okay, because I would like to object to have been excluded from this proceeding because of, I'm a discovery attorney. I make my living by signing non-disclosure agreements. But the point is, if it had been an issue, it's prejudiced my substantive and procedural due process rights. So I just like that on the record. I do not want to delay anything. I do not want to object to the presentation of the staff exhibit, but I would like my problem with my rights violation to be cured at some future point. Thank you. And I'm happy to sign a non-disclosure agreement. I've signed a couple hundred of them in 20 years. Thank you.
Right. Okay, I understand your objection. It's overruled. It's the day of the evidentiary hearing. It's a little late to be signing non-disclosure agreements and complaining about what you didn't get in discovery. Mr. Butelmans.
Thank you, Judge McClain. As our next witness, we will call Matthew Howard.
Connie, I'm going to swear him.
Raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
Matthew Howard, Matthew Howard. My business address is 3 Speen Street. That's Speen, Suite 150, Framingham, Massachusetts 01701.
Mr. Butelmans, you have anything further, any rejoinder from Mr. Howard?
I do, Your Honor.
Okay.
Mr. Howard, do you have any corrections to your pre-filed testimony?
I do. In my rebuttal, I believe it's page 31. So page 31, lines 12 and 13. I incorrectly stated that the staff of the Maryland Commission has relied on the ECAP-M. So if I could strike on line 13 the word staff, the superscript 72 and the associated footnote, and then the words as well as. So it would read, in addition, the ECAP-M has been presented by staff for the Public Utilities Commission of Nevada as recently as this year.
Thank you, Mr. Howard. Do you have any additional corrections to your testimony?
I do not.
Thank you. Moving to live rejoinder. Do you agree with Mr. McAuliffe's statement on page 5, lines 13 through 14 of his server rebuttal testimony that, quote, the lower range of his ROE results should be considered?
I do not. Mr. McAuliffe correctly excluded several of his DCF results as being not representative of the investor required return. And based on that, I don't think it is then appropriate for him to consider those results in recommending the commission look to an ROE at the bottom end, at the lower end of his range.
Did Mr. McAuliffe exclude any results from his CAPM analysis?
He did not.
Did Mr. McAuliffe place equal weight on his CAPM results?
He did not place equal weight between his DCF and CAPM results.
If Mr. McAuliffe had placed equal weight on the DCF, and CAPM results, what would be the indicated result?
If he had taken his average CAPM result and averaged that with his indicated DCF result, that would have resulted in a 9.90% ROE. And if he would have taken the midpoint of his range, that would indicate a 10%.
Thank you, Mr. Howard. Mr. McAuliffe states on page 9, lines 15 through 17 of his sir rebuttal testimony that a measured market risk premium is appropriate versus an approach that fluctuates substantially. Does your market risk premium fluctuate significantly between your direct and rebuttal?
No, it does not. In direct, my average market risk premium was 9.16%, and in rebuttal, it was 9.42%.
Your Honor, could you please raise the testimony?
Say again, sir?
Could the attorney please speak louder and the witness both? I can hear them, but I can't distinctly hear their testimony.
Okay. All right, if I could just bring it a little closer, or lean closer.
Try and move.
Is your green light on, sir?
It is on.
Okay. All right.
I'll try and speak a little louder.
Thank you.
Mr. Howard, were you done answering the last question?
I was not. I believe I was saying that my average market risk premium in my direct was 9.16%, and in rebuttal, it was, in my updated analysis with rebuttal, it was 9.42%, a difference of approximately 26 basis points.
Thank you, Mr. Howard. On page 11 of his sir rebuttal testimony, Mr. McAuliffe continues to take issue with the use of the S&P Utilities Index risk premium because it contains companies that are, quote, vastly different, noted on line 14, than Maryland Water Service. Are you using the S&P Utilities Index as a proxy group?
No, I am not. I use the S&P Utilities Index in the risk premium model. So in that model, in that model, what we're determining is the risk premium that equity investors expect over a utility bond yield. That utility bond yield is not necessarily utility specific. It can represent gas, electric, water utilities. Therefore, it's appropriate to determine that risk premium based on a commensurately broad set of utilities.
Thank you. And on page 7, lines 4 through 7 of his sir rebuttal testimony, Mr. Garrett for OPC criticizes your market risk premium for being significantly different from his. What is your response?
First, on pages 51 through 58 of my rebuttal testimony, I went through reasons why I disagree with Mr. Garrett's MRP estimates for use in the cost of capital. So based on that, I don't find his comparison to be very worthwhile. But having said that, Mr. Garrett relies on an IESA survey, and in that survey, it shows a range of estimated ERPs from 3% to 16%, the midpoint of which is 9.5%, which is higher than the MRP estimates I had in my testimony.
Thank you, Mr. Howard. I have no further live rejoinder, and the witness is available for cross-examination.
Thank you. OPC?
No questions, Your Honor.
Staff?
Thank you, Your Honor. Good morning, Mr. Howard.
Morning.
If I can refer to you, page 17 of your direct testimony.
I'm there.
Specifically referring to lines 18. So page 17, line 18 through page 18, line 7. I won't read that. If you could just take a look at that. Again, page 17, line 18.
Through what?
Page 18, line 7.
Okay. Yep.
And here you say that in determining the market risk premium component of the CAPM method, three of your four analyses are based in part on the S&P 500 market return, correct?
Correct.
Now, the fundamental principle, the big picture in determining the appropriate equity return, the ROE, return on equity, is ensuring that the return reflects the risks that the investor faces in connection with that investment. Correct?
Can you say that again?
Sure. A fundamental principle in setting an equity return is to determine that the return is comparable to the risks associated with the investment.
Yes, if the risk and return are fundamentally linked.
And I think sometimes it's referred to as the commensurate return principle or comparable return, but the concept applies. The S&P 500, of course, is comprised of companies in competitive industries. And I'll give you examples. Obviously, technology companies. You've got Microsoft, you've got Apple, you've got Hewlett-Packard. They're competing, intense competition in software, marketing software, correct?
That is correct. I would say that I'm using the S&P 500 to determine a market risk premium. I'm not using it to directly determine I'll just leave it. I'll say I'm using it to determine the MRP.
Correct, but you're using it. I mean, subject with adjustments, of course, as part of a formula. And again, in a competitive industry, if Apple develops a new software product that the public views as superior to what Microsoft's comparable product, Apple would lose revenue and customers. That's just part of the competitive environment.
Yes, presumably.
And
things can happen.
And by contrast, of course, we're dealing here with a monopoly water and sewer provider, Maryland Water Service. So that there's no risk that they can lose customers and revenue when they come in and raise their rates, correct?
Well, customers can move in and out of their service area.
Correct. But for those people who are in the development with 900 homes, everyone in that the homes are being served by that water utility, regardless of who's moving in or out. I appreciate your point. Houses turn over, but it doesn't change the fact that water is an essential service, and anyone who's living in that house has no choice but to rely on the utility for that service. Now, there we talk about the lack of competition piece. I just wanted to turn really just to one other piece of this, just to briefly review the cost trackers that you've got, that the utility relies on. Specifically, one we've already referred to here, the bulk water cost tracker. Now, in your tariff, and Your Honor, I know I'm not. If you need to see it, I have in front of me. It's part of the tariff filing. Excuse me, the rate case filing. Fourth revised sheet 2.1, the proposed red line sheet. It's dealing with the Highland Estates Water Service, and it just overview. It says that the utility can come in and file to change its rates to reflect a change in the rate that the bulk water provider is charging in connection with, this is specifically in connection with the Highland community.
I'm going to have to object to this for two reasons. First off, the witness being questioned on tariff language that is not in front of him. I think that's an issue. And then in addition, this is the ROE witness for the company. This isn't the rate-related witness. There's other witnesses available that can answer questions related to the UFW and bulk water tariff.
Yeah, I don't know if Mr. Albert has actually gotten to a question yet. Can you show him the language you're talking about?
Yes,
please?
Your Honor, I did mention that to Mr. Bugelman's, in fact, suggested that we make a copy of this for the witness. If we could take a 2-minute break, and it's just one sheet of paper.
And I believe it's applicant exhibit 2 for the tariffs.
Yeah, I would ask if the utility could just, I could run in 1 minute, or you could just give it to it's just one sheet?
I can pull it out of our binder here.
Yeah, it's sheet 2.1, and the red line version is fourth revised page 2.1.
Mr. Albert, I'm going to share with the witness the clean version. Is that
Thank
fine?
you.
Okay. If I could approach.
You may.
So if you could take a look specifically on that page 2.1, at the bottom of the page, there's a heading bulk purchase water rate.
I see that.
And if you go down a little, it says the second paragraph there, the utility is required to file with, I won't read the rest, but essentially it says the utility can come in. It puts a 90-day deadline on it, but the point here is the utility, whenever its bulk water supplier, in this instance, Highland, changes its rate, the utility can come in and make a corresponding change to flow through the chain. And if it's a rate increase, it would reflect the increase, and if it's obviously a decrease, it would reflect the decrease, correct?
Objection. Again, this is the ROE witness for the company.
Mr. Albert, why don't you get to your question? Because I'm curious as to what this has to do with ROE.
Oh, okay. Well, in fact, I wanted to then go to the latest, well, we have it in the record already, the bulk water tracker filing. We started this when you agreed with me that a fundamental principle of setting the equity return is reflect the risks associated with the company. Investors require that the return be comparable to the risks. And my point is, since this is a water utility, they only have one product. It's water. And they're in the unique situation. They have a captive customer audience. Yes, people move in and out of the homes, but everyone who lives there in the community served by this utility is going to be buying water, an essential commodity, from the utility. So the point is,
Please ask your question.
You're
Killing me.
the question is, doesn't this make a fundamental? Isn't there a fundamental difference between a utility with a monopoly audience, a monopoly customer base, and a competitive industry company? That's all I'm going with here.
Well, to go back to the risk and return,
Yes.
in this case, we all three witnesses, we developed our ROE determination based on a proxy group of comparable water companies using market data. So in order to assess if there is any adjustment needed for this bulk purchase water rate, it would have to be a comparative adjustment looking between whether or not these things are in place at the proxy group. And in my experience, the proxy group companies generally do have comparable mechanisms designed for their own unique situations. And so therefore, in terms of risk and return, you can't it's not as simple, I think, as you're looking at it.
Well, you say the proxy group, but again, I started my questions by referring to the fact that the market risk premium component of the CAPM method takes into account, in part, the S&P 500. So that's not a proxy group. That's the S&P 500, the 500 companies involved in intense competition throughout our economy.
Sorry if I jump. What was the question, the previous question you asked? Because I think I'm getting a little lost here.
Again, we started this questions with the fact that you use as a factor, certainly not the exclusive factor, but in your CAPM method, you use the S&P 500 companies.
Correct.
And those, we agree, are involved in intensely competitive industries.
Yeah.
So I'm trying to draw the distinction here, citing two things. One, the bulk purchase water, which we've already introduced in the record, the filing, and now I've referenced the tariff. And the other piece of this is the lost water. I think you call it the UFW, the unaccounted for water piece, which encompasses any water that's lost where it's not from a known cause. Again, you're protected as the utility. You're protected not only by having a captive customer base, but you're protected by the fact that you can flow through both any increase in the price of the bulk water and any loss of product. I mean, Safeway, if they lose due to shoplifting.
Let him answer your question
I'm
before
sorry,
you
Your
go
Honor.
into Safeway.
I'm not sure I heard a question there, Your Honor. I apologize. I'm just trying
No,
to.
you're not alone. You're not alone. I think what he's trying to get at is Maryland Water less risky because they have this pass-through that they can come in and they can get paid back for unaccounted for water. Is that essentially what you're asking?
Yes, yes.
So, as I initially responded, it has to do with a comparative study. It's not simply just are they more or less risky because of that. It's you have to look to the proxy groups that all three witnesses did and determine whether or not this mechanism is substantially different and provides greater protection from risk. As I said, in my experience, the proxy companies all have certain mechanisms. And to my knowledge, no other witness has provided a study that would show that this specific one would be uniquely different or confer greater protection.
One moment, Your Honor. Well, just to finish this line of questioning, I would like to mark for identification as Staff Exhibit 13. This is a filing by the utility of its tracker filing for unaccounted for water.
When was it filed?
It's dated, I did distribute this yesterday to all the parties, April 1, 2024.
Just want to make sure the record is clear.
Yes, sorry, Your Honor.
We'll mark it as 13 for identification.
And it's mail log 308629.
I've got one. Thank you.
I don't.
Are you familiar with this tracker mechanism and the fact that the utility submits filings to adjust their unaccounted for water charge to reflect the actual experience?
I'm not involved with the utilities filings. I'm the ROE expert, so this is the first time seeing this. Like I said, I wasn't involved in the filing.
Right. No, I don't suggest that you are, but you would agree with me that that again, use Safeway. If they lose product, shoplifting or accidents, they don't have a captive audience. They can just flow through a catastrophic loss. But we're talking about, excuse me, the utility has that right under this mechanism as reflected in this filing to flow through that cost to its captive customers.
I'm going to have to continue to object to this line of questioning. Again, this is the ROE witness. He answered general questions about sort of the impact of trackers related to the proxy group. But these specific questions about tariff filings that he hasn't been involved with, it's just outside of his expertise. Again, we have Mr. Schellinger here. He's the guy to ask about how these things work.
I agree. Sustained.
I'm sorry, does that mean 13 is not admitted into the record?
You haven't
Oh,
asked to
okay.
move it. Yeah.
Okay, well, yeah.
It's been identified. I
Okay,
just-
the objection, I'm sorry. Okay. Well, yeah, we would like to just cut to the chase then. Exhibit 13, again, this goes to risk. I appreciate the fact you're a finance guy, but this goes to
Questions.
risk.
Ask him questions. I don't.
Okay, yeah. As the ROE expert, I appreciate the fact that you're not involved in doing the water tracker filing, the Ellen.
Objection, Your Honor. No, there hasn't been a ruling on admission yet.
What? Well, he hasn't moved to admit it yet. He's trying to ask a question.
So again, just to tie this all up, again, because we started out my chat with you with the fact that the ROE, the equity return required by investors, has to be comparable to the risks that the investors face. And I think you'd agree with me that any company that has the right to flow through, has a captive customer base and can flow through costs and can also flow through the cost of any lost products, that would mean they face lower risk as compared to a company such as the S&P 500.
Well, I'll go back to my determining the risk for utility is a comparative exercise, like as I've been saying.
Yes, and I appreciate that. And again, you use as one of your factors the S&P 500. So that's all I have, Your Honor. I don't mean to belabor this, but we would just like to get this filing in the record as what's been marked as Staff Exhibit 13.
Okay. Any objections?
No objection.
None.
No objection, Your Honor.
All right, 13 submitted. Thank you very much. Oh, anybody?
I have some.
Wait.
Your Honor, if I may?
Sorry. I forgot
Just
about Mr. Tibbetts. Yes, sir.
Yes, I have some more cross.
Okay, just give me 1 second, sir.
Yes,
Mr.
sir.
Alberts.
Just on this same line, one other exhibit. This is the bulk water. The tariff. No, this one we already put in. I'm sorry. This is the one that we put in earlier as Staff Exhibit 11. So yes, we're done. Thank you.
All right, thank you. All right, Mr. Tibbetts.
Yes, sir. Just generally speaking, and I'm not trying to rehash anything except that in the prior cases, the utility posited and basically was accepted that investors were entitled to a rate of return of roughly 9%. Well, in terms of equity, how do you break down equity between general cost of service, et cetera, and buying something like bulk water? Or can you explore that for me? Because that would seem to be a differential.
I think that would be more of a cost of service question. Like as I was explaining to Mr. Albert, in determining the ROE, we look at the market data of proxy companies, and so that market data would reflect the
Could
entirety.
you please repeat that?
Oh.
It's unclear.
Sorry. So as I was explaining to Mr. Albert, in determining the ROE, we look to the market data of proxy group companies, which are in the water and wastewater. And so we don't specifically, and because Maryland Water doesn't have any market data, it's not possible to kind of make an assessment based directly on the risk, which is why we use the proxy companies.
Okay.
In terms of
Now,
how costs are allocated, that's
Go
a
ahead,
cost
sir.
of service question.
Yes, because the other question is, you have clearly one industry, water and sewer, with two different cost structures and returns and return mechanisms, i.e. the municipal and the private utility company. So have you addressed that in your calculations?
I have not. I would go back to what I was saying is you look at the proxy group and the market data to formulate a return on equity.
Sir, I
Yes.
literally could not hear you. I heard every other word.
As I was saying, you look to the market data of the proxy group in formulating an ROE recommendation.
Thank you.
Is that all you have, sir? Mr. Tibbetts, is that all you have, sir?
Yes, sir, that's all I
right,
got.
thank you. Mr. Bugelman's redirect.
Thank you, Your Honor. Mr. Howard, going back to Mr. Albert's initial line of questioning, can you please explain, just to make sure the record's clear, how your S&P 500 return fits into your recommended ROE and specifically the CAPM?
Sure. So the S&P 500, I I develop an estimate of the market return. From that market return, I subtract an estimate of the risk-free rate to determine a market risk premium. That market risk premium is then used in the CAPM. It's multiplied by beta as part of that formula.
And with respect to the market risk premium, you indicated that's adjusted by beta. Is that industry specific?
It is.
Thank you. I guess going to one final point that Mr. Albert raised, the analogy to Safeway and retail shrinkage or people stealing from a store. It's true that a private company like that could adjust prices to account for factors such as that, correct?
Correct.
And there's no regulatory approval necessary to do so.
Not as far as I know.
So if there's shrinkage issues related to folks stealing things, the company can deal with that by adjusting their prices charged to the public.
Correct.
Thank you. I have no further questions.
All right, thank you. Morning, sir.
Morning.
Appreciate you being here today. Your recommended ROE is still 11.15, is that correct?
Correct.
And just refresh my memory, did you do an equal weighting of your different analysis?
So I looked to the entirety of my analysis in formulating my range. If we were to look at the equal weighting of the three approaches from direct, it'd be about 10.5, 10.55. And in my updated analysis from rebuttal, it's about 10.7.
Okay. So there's no, you referenced Mr. McAuliffe didn't do an equal weighting between its CAPM and DCF, but there's obviously numerous ways to skin the cat.
That's correct. I think it's more that he excluded results, but then positioned that they should also be included in looking to the lower end of his range.
Okay. And the 9.90% that you referenced, if we did the average, or if he did the average between the CAPM and DCF, that's still below your low end of 10.15. Is that correct?
That'd be correct.
All right, thank you. Any questions based on mine?
Your Honor, could I do redirect based on the
Based
question?
on mine?
Oh, not based on what?
No.
Not allowed.
No.
Okay. Then I have nothing. Thank
Okay.
you.
Mr. Tibbetts, any questions based on mine, sir?
None, Your Honor.
Thank you. Thank you very much, sir.
Thank you.
Your Honor, is the witness excused?
Any reason to keep him around? Any objection to excusing the witness for the day?
None, Your Honor.
All right.
Thank you.
Run while you can.
Thank you.
Go ahead, Mr. Bugelmans.
Thank you, Judge McClain. As our next witness, and also our final witness for today, we will call Matthew Schellinger to the stand.
Please raise your right hand. Do you solemnly affirm on the penalty of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
Matthew Schellinger II, Matthew Schellinger. My business address is 5821 Fairview Road, Suite 401, Charlotte, North Carolina.
Thank you, Your Honor. Mr. Schellinger, do you have any corrections that you'd like to make to your pre-filed written testimony?
Yes, I do. I have a correction to my rebuttal exhibit MPS 2.
Okay, and before we do that, I will point out for the record, this is a confidential exhibit. However, the nature of the questions, I believe we do not need to go into confidential session, but I did want to point that out before we do this.
All right, appreciate that. Let me look for his. All right. Go ahead. Whenever you're ready, sir.
Thank you, Your Honor. Mr. Schellinger, could you pull up rebuttal exhibit MPS 2 if it's not in front of you already?
I have it in front of me.
Okay. Looking at this exhibit, can you please explain the correction that you'd like to make?
Yes. This Exhibit page 2 of 3, there's a series of headers. The headers get duplicated, kind of pre-allocation, post-allocation. In the post-allocation headers, the deferred comp paid out at 4/15/2021 needs to be corrected to 4/15/2023.
Do you have any other corrections?
I do not.
Thank you. Moving to live rejoinder here. Mr. Schellinger, have you reviewed Judge McLean's September 12th ruling regarding the previous settlement in this case?
I have.
And did the ruling deny the request of the company, staff, and OPC to consolidate rates of all the MWS systems?
Yes, it did.
Was that request to consolidate rates generally consistent with the litigation positions of the company, staff, and OPC?
Yes, it was.
In response to the ruling, have you prepared an updated rate design and rate comparison workbook?
I have.
And is it correct that the company submitted these workbooks in a supplemental response to PLJ DRs 1.1 and 1.2?
Yes, it is.
Thank you. Your Honor, I would like to make sure that this is in evidence. I don't know if it's going to be a PLJ exhibit or we can mark it as an applicant exhibit, but you could probably address that now.
Since it's, you prepared it more or less for
Okay.
your witness, why don't we make it an applicant exhibit? I think we're up to 21.
Yes, I request to mark it as applicant exhibit 21.
All
Thank
right,
you.
so the bench data request supplemental response will be applicant exhibit 21 for identification.
Thank you, Your Honor. Mr. Schellinger, do you have the workbooks in front of you?
Yes, I do.
Which party originally prepared the rate design workbook that you developed these revised workbooks from?
We did. MWS.
Can you please describe how you updated the rate design workbook to reflect unconsolidated rates?
Sure. I started with my rebuttal rate design workbook, which started with my direct rate design workbook. It's been updated or moved through a few different iterations for settlement discussions.
Excuse me, I can't understand you, sir.
Or just make sure it's a little bit closer.
I apologize. Is that better?
Is that better, Mr. Tibbetts?
Yes, sir, it is.
Okay. So effectively, I've triplicated our original water rate design workbook in order to develop a MWS unconsolidated rate design, a Green Ridge unconsolidated rate design, and a Provinces unconsolidated rate design using the revenue requirements for each of those systems.
Thank you. Staff witness Granum, in his direct testimony at page 10, lines 8 through 18, states that the company's rates should be offset for the revenue that MWS received for leasing space on the water towers at Provinces. Does the workbook you prepared do that?
Yes, it does.
Are you able to describe where that is shown in the workbook?
I can. It's not done in the cost of service study itself. It's done in the rate design. If you look at the water rate design unconsolidated for Provinces, the top section starts with our total rate revenue requirement and then reduces that revenue requirement by the Provinces tower lease.
Do you believe that the rates contained in the workbook with respect to unconsolidated rates are responsive to Judge McLean's directive rejecting the settlement?
I do. These rates are reflective of the company's rebuttal rate revenue requirement position.
Does the company support the adoption of unconsolidated rates in this case using the revenue allocations contained in the updated rate design workbook?
Yes, it does.
And are you able to describe how what those revenue allocations are between fixed and volumetric charges?
Yeah, generally we have proposed to keep the fixed charges at approximately 38%, with the remainder being volumetric. And then for sewer, I believe it's 40% fixed, 60% volumetric.
And is that consistent with what was proposed in the settlement?
It is.
Given that Judge McLean has rejected rate consolidation in this case, do you believe it is still appropriate to eliminate the UFW surcharge, reconciliation mechanism, and reporting requirements for Pinto and Highland Estates?
I do not believe it's appropriate.
And why is that?
I believe the original reasoning behind eliminating the UFW was due to the shared source of supply costs, and those costs are no longer shared. So I think that eliminates that concern.
Thank you. With that, Your Honor, a request to move applicant exhibit 21 into evidence.
All right. 21's admitted.
Thank you, Your Honor. Moving on to the next set of questions here. Mr. Schellinger, did you prepare the updated...
Mr. Hold on a minute.
Yes,
I know. I
sorry.
realize. No, it's my fault. I realize it's a bench data request, kind of a supplement. But is there any objection to applicant 21?
No objection.
None.
Your Honor, just a point of procedural clarification.
Sure.
So your order denied the joint application for a settlement. Is staff to take that to mean that that Your Honor has made a final order on consolidation versus unconsolidation? Because staff's position in this case is still for consolidated rates, and we're going to be moving forward based on that position.
You can certainly do that, sir.
Yes, Your Honor.
Okay, so 21's admitted.
Thank you, Your Honor. Moving to the next line of questions here. Mr. Schellinger, did you prepare the updated accounting of rate case expenses filed by the company with the commission on September 23rd, 2024? I believe it was under mail log number 312480.
Yes, I did.
Do you have that document in the binder before you?
Yes, I do.
Thank you. Your Honor, I would request to mark that filing, the rate case expense filing from yesterday, as applicant exhibit 22.
All right, it'll be so marked.
Mr. Schellinger, is the accounting in that document true and correct to the best of your ability?
It was as of yesterday. I think we could move some more from the estimate into the actuals bucket.
But other than that, it's correct.
Other than
Your
that,
Honor.
it's correct.
Okay. Your Honor, I request to move applicant exhibit 22 into evidence.
Any objections?
No objection, Your Honor.
No objection.
Go ahead, Mr. Tibbetts. Oh, did you say none?
I said, okay, for cross, okay.
Wait, no, wait. He's just moving in the exhibit. Do you have any objection to that, sir?
That's what I thought. That's what I thought. I just said no objection.
Okay, I just wanted to make sure. All right,
Okay.
22's admitted.
Thank you. Mr. Schellinger, which water systems within the MWS family do the bulk water and UFW mechanisms apply to?
The Pinto system and the Highland Estate system.
Mr. Schellinger, have you seen the UFW true filing that Mr. Albert shared with Mr. Howard?
Not recently, but I have seen it.
Would you like me to share a copy with you?
Yes.
Can I approach? Mr. Schellinger, if you look at the UFW true-up filing in front of you, do you see where it indicates that the filings are submitted, quote, pursuant to paragraph 16 of the settlement agreement filed in case number 9212 and section 3E of the settlement agreement filed in case number 9423?
I do see that.
Thank you. I have another document to distribute. If I could approach, Your Honor.
You may.
Mr. Schellinger, what is this document?
Why don't we go ahead and mark it,
Oh.
sir?
I'm sorry. Thank you, Your Honor, for
It's
the
okay.
reminder. I would request, Your Honor, to mark this document as applicant exhibit 23.
It'll be so marked.
This document is the stipulation and settlement agreement in case number 9212.
Thank you, Mr. Schellinger. Do you see where the settlement agreement reads on page 5 in paragraph 4 that, quote, in connection with any future UFW surcharge filing by MWS, staff and OPC may or may not find that annual adjusted UFW levels are reasonable and thus recoverable, depending on the circumstances of a given year and the nature and success of MWS's efforts to reduce UFW levels in that year.
I do see that.
Does this language guarantee recovery of the company's bulk water costs?
It does not.
Does the fact that recovery is not guaranteed introduce risk to MWS that it will be unable to fully recover its bulk water costs?
It does.
Thank you. Your Honor, request to move the settlement agreement from case number 9212, which is marked as applicant exhibit 23, into evidence.
Any objection to 23?
No objection.
None.
No, Your Honor.
23 is admitted.
Thank you. I have no further questions, and the witness is now available for cross-examination.
OPC?
Thank you, Your Honor. Good morning, Mr. Schellinger.
I want to move that a little bit closer to you.
Do my best, Your Honor. Good morning, Mr. Schellinger.
Good morning.
Can you please turn to page 12 of your rebuttal testimony?
I'm there.
Okay, so the first question on this page discusses the PFAS testing. Is that correct?
Yes, it does.
So starting around line 15 of the rebuttal testimony here, you state that should the commission determine the incurred PFAS costs for the test year are not to be recovered as ongoing expenses, the company proposes the commission authorize deferral and amortization to expense these costs over a 3-year period. Is that correct?
That's correct.
What is the basis of the 3-year amortization?
The basis of the 3-year amortization is that we know we're going to have additional PFAS testing costs due to the federal regulation. I believe we have at least 2 more sets of testing that's going to need to occur before 2027. And then I think by 2029, we need to have all PFAS treatment in, and then there will be some subsequent testing that starts occurring at that point to ensure we're in continued compliance. So, I mean, based on the current law, we're going to be PFAS testing forever.
And those costs, though you're speaking about, are federal required
Yes.
testing costs. But my understanding was that here you were speaking about the class action testing.
That was the, this is litigation testing costs, but they're not necessarily mutually, there's a chance that we can use those tests in order to satisfy one of the initial testing requirements for the federal requirement as well.
Okay. When does speaking about the litigation itself, when does the company anticipate that the PFAS litigation will end?
I don't think the company has any, I don't know that.
Okay. And you said that there is a chance that you could use some of the testing costs to cover maybe a test that's statutorily required. But was the decision to get involved in this class action litigation based on some sort of federal requirement, or was that a business decision?
It was a business decision.
Was that decision based on any chance of prevailing in the lawsuit?
The business decision was made in order to potentially mitigate future costs that would be borne by MWS customers.
Irrespective of the prevailing in the lawsuit?
The company should pursue those funds regardless of if they succeed or not in order to help mitigate the costs for the MWS customers, yes.
Okay, but so the company has no position on the likelihood of the company prevailing in the lawsuit itself?
I'm not aware of any.
Thank you. No further questions. All right.
Mr. Grigger?
Good morning. And if any of these questions are stale based on the company's new workbooks or updated rate design, please let me know.
Okay.
So I am referring to a rebuttal testimony on page 16, and I'm specifically looking at the discussion on staff's recommendation concerning the bulk water purchase rate the UFW surcharge and the UFW reporting requirements. So this might be a little redundant, but you oppose staff's recommendation to discontinue this current pass-through process, correct? Or the company opposes staff's recommendation to discontinue the current pass-through process, correct?
It does.
Now, to level set, could you briefly explain the purpose of these charges?
Purpose of the UFW charges?
Yes.
Yeah, we don't have wells in the Pinto and Highland Estate system, so we purchase water through a third party, and these costs get passed on to the customers for the
Could
cost
you
of-
speak up, please?
Could you restate
Sorry.
that, please, sir?
Yeah, we purchase water from third parties and pass the cost on to the customers in those systems.
Yeah, thank you. Now, MWS has facilities in service to supply water to provinces and Green Ridge systems, correct?
Yes,
And NWS has costs associated with supplying water to the provinces and Green Ridge systems. Is that also correct?
yes,
Now, the rates proposed by NWS in this proceeding are based on the cost of service study proposed by company witness Miller. Is that accurate?
correct.
Okay. So those proposed rates include costs related to providing water supply to the provinces and Green Ridge systems.
Based on our unconsolidated rate design that we've provided recently, that I'm not sure I'm not sure that any of that's applicable anymore.
Okay. And that's kind of what I want to clear up, whether that's still the case or not. So if NWS needed to construct a new well to supply water to provinces or Green Ridge, or in general make improvements to these systems, would these costs be shared by Pinto and Highland Estates customers under NWS's updated proposed rates?
They would not. Under the unconsolidated proposal, if provinces needs a new well, then the province's customers would pay for that new well.
Okay. So, and I suppose that's the same for increased operational costs, such as chemical or power costs?
That's correct.
Okay, I think I can move on. Do you happen to have a copy of staff witnesses DeMaster's direct testimony in front of you?
I don't believe I do.
Okay, one second. Wondering if the applicant's counsel could supply a copy of that testimony. That's the direct testimony of Christine DeMaster.
Just to clarify, do you mean the errata or the original version?
Yes, the errata would be the updated with the line numbers. So I think that would be easier to reference.
I would agree.
Thank you for bearing with us here.
Oh, no.
Take your time.
If I can approach.
You may.
I'm specifically looking at Table 6, which is showing the customer bill impacts of...
What page are you on, sir?
I'm sorry. I'm on page 42 and 43.
All right, thank you.
Now, I imagine this information is a little out of date given the company's updated unconsolidated rate design. But at the time of filing NWS's proposed rates, I'm looking at page 43 on that last half of Table 6, the proposed rates. For the provinces, the residential average was at 93%, and the residential large was at 103%. Can you briefly describe the bill impact changes that result from the company's updated unconsolidated rate design?
Give me just a minute, please.
Of course.
In the updated, unconsolidated response that we provided, there's a table called Calculation of Average Bills, which presents the unconsolidated rebuttal proposed rates. For Green Ridge, the average percent increase for residential will be 52%, Provinces 40%, Highland Estates 35%, without the bulk water surcharge, and then Pinto 35% without the bulk water surcharge.
And do you happen to know what impact the bulk water surcharge would have on those last two systems?
Sure. Highland Estates with the bulk water surcharge is the 24% increase, and Pinto it's a 24% increase.
Thank you. I just had one last question. Oh, I'm referring to your direct testimony, exhibit MPS 10. I think that's the last exhibit you had in your direct testimony. It's titled Revenue Proofs.
Yes.
And I'm looking at page 2 of 2. Again, specifically at the Provinces. It looks like Provinces has one commercial customer. And just to clarify, under revenues, it has the $17,055. Is that would that be the annual cost associated or attributed to that commercial customer under your previous rate design?
That would have been the rate design from the direct testimony, not the rate design from the most recent bench DR.
Yes, and can you describe how that would change for that commercial customer?
Yeah. So the reality is that commercial customer has a 6-inch meter. So if we were to go with, strict rate design following the AWWA equivalents for a 6-inch meter, it'd be a very significant increase for that customer. So in order to mitigate that, we're effectively proposing to treat that customer as a 1.5-inch meter, which drops the equivalence from 50 down to 5. So it significantly mitigates the rate impact on that customer.
Understood. Thank you. That's all the questions I had, Your Honor.
What's before you move on? What's the percentage of what they're looking at before and now, if you have that?
Percentage from my direct testimony versus percentage now, or
Yes, sir.
from the current to propose?
Current to propose, what we have in the updated, please. Oh, I thought you might have that in front of you. My apologies, Mr. Buehlman, for jumping in.
So just for comparison, in my direct testimony, we were originally looking to recover $17,055 from that customer, and in the revised numbers, we're looking to recover $1,395. So it's a significant reduction. I believe the increase from their current rates is, I think it's a little bit lower than Provinces as a total, but it's in that same ballpark.
All right, thank you. Mr. Tibbetts.
Yes.
Do you have any cross-examination, sir?
Yes, I do.
All right.
Number one, when you design the new rate increases, did you factor in? Let me back up a second. We've always heard in this discussion about rate shock. Well, have you considered the rate shock for designing your current rate increases? Have you factored in the current rate shock for the future demand increases? What I'm saying is that if you look at Bel Air, I'm just giving you an approximation. It's like if you look at the 35% increase last approved, or 30% plus the bulk water increase, it works out to like roughly a 79% increase before this case. So question is, has that was a demand, that's demand depressor. Has that been factored into the protections of usage?
We have not factored any consumption repression or demand reductions in this case. That would only actually serve to increase the rates.
Sir, I
necessary.
cannot hear you.
Sorry. We've not factored any consumption decline or demand repression in these rates. If we did, that would only actually serve to increase the rates necessary in order to recover our revenue requirement.
Okay, thank you on that. Now, number two, it's like, does the company pursue its rights of appeal to the increases in whatever rights of appeal they may have? It's like, because it seems like, maybe tell me if it's wrong, but it seems like your profit is keyed on something just based on bulk water. Okay, then that translates into a cost of operation, A times B equals C, so that translates to property. But the question is, do you have any ability to negotiate decreases with the providers to start with, and do you do so? Thank you.
Generally, I believe we're charged the actual tariffed rate from those municipalities. We are treated the same as every other customer. So no, we don't have a negotiated rate.
Okay, thank you.
Is that all, sir?
Yes, sir.
All right, thank you. Mr. Bugelman's redirect.
Thank you, Your Honor. I have a few questions. Mr. Schellinger, with respect to the rate workbooks that you prepared, were the workbooks prepared in response to the judge's ruling with respect to rate consolidation?
Yes, they were.
And then moving to the bulk water surcharge, has the company proposed in this case to change the bulk purchase water amounts or anything related to the surcharge in the company's current position?
We have not. The bulk water surcharge is handled in its own separate filing.
And with respect to the latest increase, was that already approved by the commission?
Yes, it was.
Thank you. I have no further questions.
All right, thank you, sir. Good morning.
Morning.
All right. Do you happen to have Staff Witness Riley's surrebuttal in front of you, sir?
I believe I do.
All right, I just have a few questions on that. You turn to page 6. Let me know when you're there.
I believe I'm there.
All right. On the question and answer, starting on line 9, Mr. Riley points out, I guess I'll call it a discrepancy, and he made an adjustment. Do you have a position on, or can you explain the discrepancy noted by Mr. Riley? And some of this is confidential. Are you in surrebuttal?
Surrebuttal?
Yes, sir.
Page 6.
Page 6, yes, sir.
The question starts on line 9.
Yes, sir. Does staff agree?
If you'll give me just a second to read.
Oh, absolutely. I'm sorry. I jumped.
Okay. I have read it.
Okay.
I'm not sure the exact nature of the discrepancy between my originally filed exhibit MPS 6 and then the rebuttal exhibit without going back through and doing a apples to apples comparison, but I have no problem supporting my rebuttal exhibit.
Okay. All right. So you're obviously maintaining your position on that?
Yes.
Okay. All right. Skipping down to the next Q&A, sir. Well, starting on line 20, if you could just read that and let me know when you're done, sir.
I've read it.
Okay. Do you agree with the confidential portion of that and the removal of that particular amount?
I do not agree with that for two reasons, really. First off, as I indicated earlier in my correction, that was just an error in the title. That wasn't representative of April 15th, 2021. It was representative of what was paid out April 15th, 2023.
Okay.
Second to that, it ends up becoming a duplicative adjustment because he's thrown out certain incentive compensation associated with financials and then also thrown out all deferred comp. So I think you've arguably thrown out too much. You can only go up to the max, and I think by having the incentive comp on top of the max, you've definitely thrown out too much there.
Okay. All right, thank you. If I could get you to turn to the next page, please, sir. And just have on that very first Q&A, if you could just read that over and let me know when you're done, sir.
I've read it.
Okay. Is that something you can respond to without going into confidential session?
Yeah, so
Okay.
my initial response is Maryland's a strict historic test year state, and he's making an adjustment for items that have occurred outside of the test year, but pretty much in isolation here, right? He's only made a single pointed adjustment without updating everything else, all the plant that's been put in up through that date, changes in chemicals, testing, everything else. It's a very isolated adjustment. So I would argue that it should be, that by itself should be taken into account. Because you can't just grab one item and say, well, overtime went down, but maybe overtime was high in conjunction with all the other items that were occurring during that test year. So I think that'd be the most poignant response to that.
Okay. All right, thank you, sir. Bear with me for 1 second. Last question, sir, or last area. The Oracle Fusion asset, sir?
Yes.
OPC witness Morgan stated it was more appropriate to pass through the return through the corporate service charges rather than including rate base. Do you have an opinion on that statement, sir?
I think from a math revenue requirement perspective, it ends up being approximately the same. In most jurisdictions that I've worked in, it's just treated as a rate-based item. I think it's a little easier than having kind of this back-end math going on, but I'm not sure that I take a strong position on either.
Okay.
Treatment.
All right.
Your Honor, I can understand it. I could not hear his answer.
Okay. Could you restate your answer, please,
Yeah.
sir?
I think from a revenue requirement math perspective, it ends up giving you virtually the same result, so long as you're using the full weighted average cost of capital and making that calculation. I think it's easier to just roll it through as a rate-based item because then you don't have to do all of that back-end math. But outside of that, I don't take a strong position either way.
Okay. Did you get that, sir, Mr. Tibbetts?
Not completely at the end.
All right. I'm sorry. Could you just kind of get a little bit closer? Thank you.
From a strict revenue requirement perspective, I think it's roughly equal as long as you're using the weighted average cost of capital in the calculation. It's probably largely just presentation, so I'm not opposed to either direction.
How was that, sir?
That is adequate. Thank you.
Excellent. All right. Thank you. That's all I have. Don't go anywhere. Any questions based on mine? Mr. Bugelmans?
No, Your Honor.
Mr. Miller?
Your Honor.
Mr. Greger?
No, Your Honor.
Do you have any follow-up questions, Mr. Tibbetts, based on mine?
None, Your Honor.
All right. Thank you very much. All right. We're at 12:05. How's everybody feeling? Do we want to keep pressing? Do we want to take lunch? I'm fine either way.
Your Honor, it may depend on what the company asks for questions for staff, or Mr. Tibbetts as well.
Sure.
I have a decent number of questions for staff's witnesses. I mean, we could do one witness now. We could do lunch. We're open. I mean,
Why-
it is
why-
lunchtime, so.
Okay, let's do lunch now. Is an hour good?
Sure.
All right, so we're going to go off the record, and we'll come back on at 1:10 p.m. and we'll start up with OPC. No, is that right? No, I'm
Your
sorry.
Honor, our witness is coming
That's
Friday.
right. That's
Yes.
right. If needed. All right, we'll start up with staff.
Yes, Your Honor.
Any reason to keep Mr. Schillinger around? No. We'll see. No, no, I didn't stop. The stream is on. The stream is on. Okay, good. So here, the thing is that I can coordinate with you to start the stream from my side. Okay. Well, yeah. Instead of pushing buttons here, I can start it here and stop it whenever you want to stop. Good point. Okay. And for when you go confidential, just mute the sound like you did right now. See what I mean? And you can leave the stream on. You don't have to cut the stream. Okay, yeah, well, hopefully I won't have to do that. Why isn't this letting me share my screen? We're trying to share with my screen. Through Zoom? Yeah. Okay. Yeah, so, where is the Zoom app? So this is the Zoom app. Okay. Share screen. Share screen. So it's going to ask you what you want to share. Share device. Okay. Click on share. Okay, one second. Share. Press only. Okay. So that's fine. Click out of it. So share what you want to share. And then it will share. Make it bigger. Make it a full screen. This is full screen. Oh, and Zoom. See, I don't know. This is basically a full screen. It's just you see the slides. If you escape or push F11, look what's going to happen when I push F11, but I'm like this. Yeah, yeah. But this is when you have the app. If you have the app, this is what is this? PDF? PowerPoint. PowerPoint, then you go to PowerPoint app. Just pull up PowerPoint. You don't have to pull it up in, you're pulling it, PowerPoint, you're pulling it in Google. So Thanks for your help today.
You're very
Appreciate
welcome.
it.
Actually, you see, I have to understand the system.
I don't understand what happened.
I'm not
And then it
saying
just kind of went back up. How are you, Connie?
I'm good. What happened when we went into confidential?
Oh, I know what's going on. I'm not even gonna worry about this anymore.
Is it open?
I'm not even gonna worry about it.
Why?
It's just, you know, I don't wanna make a whole new slide, and it's got,
It's already in PowerPoint presentation. It's already in PowerPoint. Where's your presentation?
I, you know, I can,
Show me the location of your
okay,
presentation.
so this is how I got into it. I went into it.
Okay. From here,
Yeah.
just download
I went in,
from
I
there.
went in,
Go to back. Okay, right click on it. Right click.
download.
Yeah, download. It's gonna go into your download. Once it's downloaded, go here. Yeah. It's gonna open your PowerPoint. Very careful. Okay, that's fine. Download PowerPoint. Open the file.
This is just.
Let
too
me
much
fix
overhead.
PowerPoint.
Don't,
for you.
it's,
It's in Office 365. I can put Office 365 for you quickly, and then you can probably log in with your credentials.
okay, well, I already logged in with this, I logged in with my credentials. That's how,
To Office 365.
I don't,
This
just,
is 2010. But Office 365, everyone who sits here, he has to log in with his credentials. Chuck, that's the problem
Right.
with this 365. But let me see if this one opens up. Yeah, it opens up. Okay. So file, open, downloads. There it is. Let's open this. It sees it as damage. PTX. That's not gonna work. It sees it as damage.
I'm sorry, go ahead.
It sees it as damage.
It's, don't worry about it.
So you wanna open it here and that's it.
Yeah, I would, like with PowerPoint, you can make it like the whole thing,
I
but
know.
it's fine.
See, I can go like this, like that.
That's fine.
But
That's fine.
F11 will maximize the
Okay.
screen, but it's still gonna show you those
That's
two.
fine.
And
Ooh,
when-
look, slideshow, maybe that's it.
Okay,
Good
yeah, there
slideshow.
it is. All right. Oh, there it is.
That's what I want, okay.
Man, you use this stuff.
All right,
I don't
so
use it.
now
All
we
right,
have to go
so
down
we will
to,
go and, okay, that's it.
Okay.
It's done. You don't have to worry about it. Slideshow, yeah. Because
So-
the PowerPoint has slideshow. Now what do you
So-
wanna do? Got it? Push F11. F11 will
So-
give you,
share screen. See, now it's not there.
that's your screen, isn't it?
Yeah, but where's the,
Yeah, that's your screen. Click on there. You're already sharing the screen. So what you do is that now that's the move there and put slideshow and you're done.
Oh.
That's it. Because it's already highlighted as your screen. What a mess. So when do you finish this? You think like what time?
it's really gonna depend on,
You text me and I will stop or you stop it yourself.
I can stop it. Stopping it's not the problem,
be a check, so I don't wanna take much of your
Yeah.
time. When you wanna play,
Right,
you click on that.
right, okay,
This three, and this one.
okay.
When you
And
wanna
then the square
pause,
is,
this is pause, and
Okay.
this is stop.
okay, so
On
probably
the
just
back.
hit the pause during the confidential rather than stopping the entire stream.
Probably that's the best thing to do, and
Okay.
then when you resume, you wanna go back to, and I don't know if you uncheck pause and push the other one, or, see, I don't know the system.
Yeah, all right.
But
well,
I can do it through the
yeah.
app for you.
Okay, well, don't, I think I'm good for now. So,
Oh, now, okay, hold it.
thanks again.
I was worried that the system was failing or something. They're gonna be
didn't make it so you can't take it out as a wire effectively for various reasons. So this is what we're doing.
mean, and I don't know what's gonna happen with OPC either, but if their witnesses are gonna be virtual, we can just do it virtual.
That would be
Friday, if need be, and, and then if we need, are you around Friday, just in case, I'm not, okay. I can't imagine it would be long on Friday if we needed it at all. Mr. Tibbetts, you hear me okay? Mr. Tibbetts? You there, sir? Mr. Tibbetts? Mr. Tibbetts, can you hear me, sir? Can you turn on your camera? Mr. Tibbetts? Feels like a Monday. Mr. Tibbetts? Oh, now he's gone. Oh, there he is. All right, there we are. Can you hear me, sir? All right. Got a salute there. All right, we all set? All right, we're back on the record. Any housekeeping before we continue?
No, Your Honor.
All right, Mr. Albert.
Your Honor, staff calls its next witness Drew McAuliffe.
Watch your step, sir.
Raise your right hand. Do you solemnly affirm under penalties of perjury that statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
Drew McAuliffe, McAulliffe. My business address is 6 St. Paul Street, Baltimore, Maryland.
Whenever you're ready, sir. Or do you have any? Okay, you don't have any.
Yeah,
Okay.
yeah, no, nothing, Your
Mr.
Honor.
Bugelmans, do you have any cross?
I do have some cross, Your Honor.
Everything's been
All right.
admitted
Yeah, everything is-
during the settlement
Sorry.
hearing, so that was.
That's right.
No, you're not alone. Don't worry about it.
Thank you for checking, Mr. McAuliffe. On page 5, line 16 through page 6, line 21 of your testimony,
Direct.
of your sir rebuttal testimony. Able to pull that up?
I have it. Yeah, just 1 second.
So can you give that site again, please?
Sure. Page 5, line 16 through page 6, line 21
Thank
of
you.
Mr. McAuliffe's sir rebuttal. Mr. McAuliffe, in that section of your sir rebuttal, you reiterate your position that the commission should consider gradualism as a factor to influence the awarded ROE. Is that right?
Yes, that's correct.
And isn't the concept of gradualism typically applied with respect to customer rate design?
It is also applied in the context of customer rate design, but this commission has cited in many orders gradualism when awarding ROEs.
Are you aware of a financial textbook or publication that recommends investors consider gradualism in assessing the cost of common equity?
I've not researched that, so I'm not aware.
So your conclusions are based off of commission precedent and that alone?
Yes, yeah, as a staff witness, and precedent is obviously very key to all decisions before the commission. So if there's a a precedential decision that the commission has made many times over. As staff, we have to acknowledge that and make adjustments accordingly.
Mr. McAuliffe, am I correct in assuming that you've never recommended a return on equity higher than what was recommended by an applicant's witness in a rate case?
Higher than a utility witness? No, yeah, that's fair to say. I have not recommended a higher ROE than a utility witness.
And is it correct that in most rate cases, and in this case specifically, the various ROE witnesses use the same basic models and inputs, but then they make adjustments based on their professional judgments and then come to different results? Is that a fair characterization?
That's a fair characterization. Some witnesses use different models, though. For example, I did not use the risk premium where the MWS witness did, for example.
And some of these recommendations, yes.
Everybody on Zoom, can you guys see and hear okay? Can you guys? They can't see. All right, I'm getting. Wait. My fault. Can you hear me now? Can you hear me now?
Yes.
All right. Can you see?
We do not have video.
All right.
I can see you. I have it. Well, no, we don't. I can't see you.
All right. Hold on. Why is this not? Click on start video and it's not starting. All right. So fair to say you guys didn't hear anything Mr. McAuliffe has said so far?
That is correct. We did not hear any of it.
Excellent. All right. So that's obviously on us. All right. Just stand by, everybody. All right. The video is not starting for some reason. That guy. How about now? How about now?
Yes, we can.
Yes, we can see you and hear you.
Excellent. All right. I'm sorry. I'm going to have to ask you to start over.
It's
just for
completely
Mr.
fine. I
Tibbetts.
understand.
Okay.
So I'll start over.
All right. So if you want to change your answer, you can. I'm obviously,
I hope not.
I'm kidding. I'm kidding.
Didn't get too far.
Yeah.
Okay. Starting from the beginning, Mr. McAuliffe, on page 5, line 16.
I can't hear him distinctly.
Mr. McAuliffe, on page 5, line 16 through page 6, line 21 of your rebuttal testimony, you reiterate your position that the commission should consider gradualism as a factor to influence the awarded ROE, correct?
That's correct.
And the concept of gradualism is typically applied with respect to customer rate design. Is that right?
It is also applied in the context of rate design. This commission has cited in many orders the use of gradualism when awarding ROEs as well.
Have you been able to identify any financial textbook, publication, article that has recommended that investors consider gradualism in assessing the cost of common equity?
I have not specifically researched that topic, but no, I have not seen any of that.
So your testimony is based entirely on past commission precedent?
For the use of gradualism and ROE, yes, that is based solely on commission precedent that has been cited in multiple orders over the past many years.
Mr. McAuliffe, am I correct in assuming that you have never recommended a return on equity higher than what was recommended by an applicant's witness?
Yes, I've never recommended an ROE higher than a utility internal witness or outside consultant witness.
And is it correct that in most rate cases, and in this case specifically, the various ROE witnesses use the same basic models and inputs, but then they make adjustments based on their professional judgment and then therefore come to different results?
Generally, that's correct. Some witnesses use different models. So for example, witness Howard used a risk premium where I did not. I believe all the witnesses used a DCF and CAP-M. But the inputs to the models can differ as well. But yes, generally speaking, the models and assumptions are fairly similar.
And your recommendations also necessarily involve future predictions. Is that correct?
Yes, there are some future predictions, I guess is how you phrased it, in any ROE analysis.
Could you speak up again?
You're really determining the what the return on equity will be, not what it is in the past. So there are some projections.
And it's fair to say none of us have a crystal ball. We can't see into the future, predict what's actually going to happen.
That is fair to say that economic projections in particular are usually inaccurate. Yes.
For example, in your testimony, you make assumptions about expected changes in interest rates in the coming months and years. Is that right?
Yes, that's fair. I bring up the Federal Reserve specifically and their what was assumed to be their path of reducing rates, and we have actually seen that as of last week. They have begun to cut interest rates and have signaled that they will continue to do so, at least in the near future.
So you do have a crystal ball.
Yeah.
Well, to that point, isn't it true that conventional wisdom was actually that we would have seen these reductions to interest rates by the Fed earlier than we actually saw materialize this past week?
I don't think so. I mean, obviously, everyone has their own opinion. There were some whispers that they may cut in July. But, with this cut that the Fed did last week in September, there were assumptions that it would be a 25 basis point cut, and they went to 50, which did surprise some people as well. So I don't think it's fair to say they would have cut earlier necessarily. As they've been saying, they're data dependent. So as the data came in, they began to adjust their assumptions. But they've started the cutting cycle and have clearly indicated we are in a cutting cycle, and they need to get to what's called the neutral rate, where they're not being restrictive or supportive of the economy. It's just, you reach that equilibrium. So they're on their way to that. That number is anywhere from 2.5% to 3.5% is the guess. But again, that's up to the Federal Reserve. And currently we're at 4.75 to 5% on the federal funds rate. So we do have some ways to go to get to that neutral rate.
But to your point, the Fed makes decisions based off of what it anticipates will happen or certain market reactions to what it does. So for instance, it made a 50 basis point reduction in interest rates, but that was based off of assumptions that the market would react in certain ways, which may not actually pan out. Is that a fair statement?
No, actually, I would completely disagree. They don't make any decision based on the market. They have their dual mandate of inflation and employment levels. So they're not concerned with what the stock market thinks of whether they're increasing rates or decreasing rates, and that's really not in their calculus. So they're getting the data as they receive it, whether it's PCE or the various inflation gauges and all the unemployment rates and various employment data, and they're taking that data into account and making their decisions based on that. But the Fed has stated many times they're not concerned with what the market does. That's not really their job.
Is it possible that as a result of the Fed's recent actions, we could see an unexpected spike in inflation? Is that a possible outcome?
I guess anything's possible, but they're still in restrictive territory, as I was describing earlier. So they believe that where they've set interest rates will still put downward, pressure on the economy, which should, as economic theory goes, limit economic activity and therefore, keep inflation in check. But again, anything's possible. There could be supply issues, strikes, but, just using the basic economic theory, we're still in restrictive territory, so we wouldn't expect inflation to increase.
Is potential global unrest a potential factor?
Your Honor, objection. This is, we've allowed a few questions here, but it's just a string of asking for a lot of speculation about a third entity, the Federal Reserve, that I don't think it's fair to be asking a staff witness this.
Overruled, if you know.
So you brought geopolitical, I believe, was your question.
Yep.
I mean, I know there's no expectation that inflation will increase, but sure, anything can happen. If an asteroid hit, I would expect inflation to increase as well. But yes, there could be a myriad of things that cause an inflation spike. So, but there's nothing to show that should increase now based on what we currently know and the data we currently have.
I think we could put the asteroid strike aside, but some of these other factors, if they were to materialize, the Fed could react by actually slowing what it's doing or actually increasing rates. Is that a possibility?
Based on geopolitical tensions, I don't think that would be their cause, a reason to do that. We obviously during the COVID pandemic, they cut rates to zero. So I would actually expect probably a reaction more in the other direction. Oil prices haven't spiked or anything with any of the current geopolitical tension. Actually, they're at their lowest level in quite a while. So again, it's hard to say what they would do. You'd have to know all the factors at that time.
If the commission bakes into its decision an assumption of decreasing rates, is it true that would also make it more difficult for the utility in this case to attract capital?
I don't believe so.
Why is that?
Well, the interest rates should decrease across the economy. They'll still be based on the factors they currently are. MWS will still have to compete with all other companies and the Federal Reserve itself selling their own debt. So, no, I don't see why it would change necessarily. I would argue that all else being equal would be about the same.
If the assumption is incorrect, would that impact the ability of the company to attract capital?
If what assumption was incorrect?
If it bakes in an incorrect assumption of decreasing rates?
I don't think so. Just looking at awarded ROEs nationwide, I recommended 9.75. I think is more than fair. Now, if the recommended ROE was drastically lower than what else is being awarded around the country, you could have an argument that maybe that would hurt MWS's ability to attract capital. But based on my analysis, I think it's more than fair.
You indicated earlier that your testimony, at least in some other areas, is based off a commission precedent. Do you believe that it's true that in rate cases, the commission is often deciding between a higher rate of return, which could benefit the company, versus a lower rate of return, which presumably could benefit customers in the short term with lower rates from the utility? Is that a trade-off you think happens?
Are you're asking him how the commission's deciding ROEs? How is a staff witness going to know that, sir? That's to you. What goes on behind closed doors in the commission deliberations? That goes back to the asteroid. Anything could happen. If you want to try it a different way, you can, but I don't think there's any way anyone in this room could answer that question, me included.
Okay. Mr. McAuliffe, when determining your testimony in a rate case, are you thinking about the trade-off between the benefit to the company of a higher ROE and therefore higher rates versus the potential benefit to customers as a result of a lower ROE? Is that a trade-off that you're thinking about?
No. So my results are purely based on my analysis, and then as I cite, if gradualism becomes an issue, that may be used to determine my final number as well. But again, it's still based off my analysis of the numbers that I've crunched. So no, that trade-off does not come into my thought process.
Is it correct that if the commission, in this case, adopts a lower return on equity, that can result in the utility having a hard time attracting the necessary capital investment to maintain the system?
Well, I guess as I stated earlier, I believe my recommendation is more than fair and should not cause MWS any issues with attracting capital, in my opinion.
Is it correct, based off your experience with rate cases at the commission, that often when utilities come in, and clearly they end up, typically do not end up over-earning on their rate of return? Is that right?
That's hard to say. They definitely do over-earn at points. I can't say whether it's more likely or not. But you would expect when a utility's filing a case that they are looking for more revenue. So they probably haven't been hitting their rate of return. But again, it's hard to say. I've seen it both ways. If a company hasn't come in for a rate case for many years, you would expect that they would start to earn less than their return as they've increased their rate base and things like that.
And in this case, are you aware that the companies during the test year was earning less than a 2% rate of return? Is that right?
I don't recall, subject to check. I trust your number.
Is it correct, just generally speaking, companies are under earning that results in them coming in potentially more often for rate cases?
That's a possibility. Sure.
And that's expensive and administrative burden, correct?
On whom?
For the company and for the commission.
A burden is a strong word, but we have rate cases every year from many utilities. But yes, sure they would have to file more often, which would be slightly more costly. But if their rates were drastically higher because a much higher ROE, that would be even more costly.
And you're aware staff supports recovery of rate case expense up until the day before the hearing?
I believe so. I'm not the accounting witness, but that sounds accurate.
Okay. All right. I have no further questions. Thank you.
All right. OPC.
No questions, Your Honor.
Mr. Tibbetts.
Yes, sir. Question, you made a great, we understand you don't have a crystal ball. Do you have a retrospective ball? It's like you got a 9% return based on industry standards that people weren't flocking in. Well, have you evidence of your increased revenue rate of return has actually attracted investors or not? Has it worked?
Well, so this rate of return has not been awarded yet, so it's hard to say whether it's attracting more investors.
Could you repeat that, sir?
This rate of return hasn't been awarded yet. I believe your question was, is this attracting more investors?
Oh, but you just finished a 3-year cycle of a higher return, a rate increase that was returned. So what happened with the past? Did it work or did it not? I can see that. I'm not trying to rehash this, except I can see that a negative 1% return is not good for anybody. But on the other hand, you had to ask for 9 and got a 9. So, what's been the effect on the investment?
I really can't say.
Okay. Thank you. No further questions.
Mr. Albert, redirect.
No redirect.
Okay. Good afternoon, sir. Just very quickly, assuming our utilities were to get higher ROEs, such as they're requesting in this case, do you think that automatically makes it easier for them to earn that rate of return?
It depends. So obviously the rate of return has, two factors. Also, how much they're spending. If they got a higher rate of return, they may feel more emboldened to spend more, which would then decrease their rate of return. So while their revenues would increase, it's hard to say how any company would react to that kind of windfall of extra revenues, and they may decide, hey, we'll upgrade some of our facilities, which would increase their expenses and decrease the rate of return.
Okay, so it's not a silver bullet, so to speak.
No, not necessarily. And just because you're under earning to a larger degree doesn't mean you need a equal and opposite increase on the opposite end. You just need to, if your rate of return you want it to be 7%, just because you're at 2 now doesn't mean you should get like extra to get up to that 7. It is what it is. So.
All right, thank you, sir. Any questions based on mine?
Yes, Your Honor. Just simply, you referenced, granted earlier, but it's followed up in this section. You referenced the general rate of return, inflation, the Federal Reserve, all that. Well, what evidence do you have that your investors are actually responding to the general economy or not? I mean, it's like there is a certain pool of people who are going to invest in utilities. So have the rate increases attracted them or not? Because that seems to be reasonable.
Well, it's hard to say. Again, particularly in Maryland, most of our utilities are not publicly traded entities. I guess the only way you'd really notice is with their debt issuances, if they were having issues issuing debt.
Could you repeat that? Sorry, I couldn't hear you.
So debt issuances, I guess, would be the only way we would really track that, particularly in Maryland. Most of our utilities are not publicly traded, on the New York Stock Exchange. So, again, it's hard to say if we've seen any pros or cons. I'm not aware of just say MWS's credit rating off the top of my head, whether it's gone up or down recently. But again, if they were having trouble issuing debt, that would be a clear red flag. But again, it's hard to say if they're still issuing their debt. It's hard to say whether they had a robust response to their debt issuance or just a normal one. You wouldn't really know because they're only issuing a finite amount. If that answers your question.
Thank you.
All right. Seeing none? Appreciate your time, sir.
Staff would call to the stand witness Mark Riley.
Watch your step, sir.
Yeah.
Please raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
My name is Mark Riley, MarkRielly, and my business address is 6 St. Paul Street, Baltimore, Maryland, 21202.
Thank you.
Well, I guess I should ask. Obviously, we introduced the testimony in at the settlement conference. Did anything since then? Any corrections? Anything you saw that needed to be corrected before you get questions on cross?
No.
Okay, just want to confirm that.
This is going to be based on my surrebuttal testimony.
Mr. Riley, if I could just encourage you to get a little closer
Oh,
to the mic.
okay.
So, or if you want to move it however you're comfortable. Thank you. All right.
Yeah, no, you'll be cross-examined on all your
Okay.
direct and surrebuttal. Just want to know if you saw any things that needed to be corrected.
No, the settlement testimony was joint testimony. Parts were mine and parts
Right.
were.
No, I mean, I'm talking about the non-settlement testimony.
Okay, yes.
No corrections. Okay, just wanted to confirm that.
Mr. Bugelmans?
Thank you, Your Honor. Mr. Riley, nice to see you. My first set of questions for you are related to your surrebuttal work papers. Do you have copies of those in front of you? I'll tell you which one to look at in a minute.
I have copies of the exhibits, yes.
Okay. That's right. So let's first move to your surrebuttal exhibit MR-R.4, which is the summary of operating income for provinces. Do you have that in front of you?
Okay, MR-R.
What was that? MR-R-4.
4.
All right. Towards the end, sir. You got it?
I've got it in front of me.
Thank you, Mr. Riley. Looking at row 2, you've stated that operating revenues for provinces total $850,942. Is that right?
Correct.
Are you sure that's the correct number?
To the best of my knowledge is correct. Is there a different number from the company?
I believe so. We'll walk through that here. Do you have in your packet Exhibit MPS 4, which was attached to company witness Schellinger's direct testimony? And if you don't have a copy, I could get you a copy.
All right.
Is that direct or rebuttal?
It should be
Direct.
Sorry, could you give me that citation again, please?
Sure. It's Exhibit MPS 4, which was attached to company witness Schellinger's direct testimony.
Provide that to me.
May I approach, Your Honor, to
may.
provide this?
Certainly.
Okay, thank you.
Okay, so looking at Schedule B of Exhibit MPS 4, which is what you have in front of you, Mr. Riley.
Did you say D or B?
B.
B. All right. Go ahead.
So Schedule B is the province's water operations pro forma income statement. Please refer to line 7 under the test year as adjusted column. Do you see that?
So we're on Schedule A?
Schedule B.
Schedule B, thanks.
Okay, so you're saying line 7, column E, correct? Test year as adjusted.
Correct.
Yes, it says 830,942.
Thank you for that. Shouldn't this number, or this lower number of $830,942 been input on your surrebuttal exhibit MR4 instead of the $850,000 number?
Yes, I'd say the 5 should have been a 3,
Okay. So it was a typo, basically.
to the best of my knowledge.
Okay. Okay, let's now move to your surrebuttal exhibit MR1. Do you have that in front of you? And Mr. Riley, it's also the paper I gave you. It's the last page of what I gave you. That makes it easier.
Okay. All right, I'm on exhibit MR1.
Okay, so if you look at the column all the way on the right for staff's proposed revenue requirement, on line 3, you're showing a total combined consolidated incremental revenue requirement of $1,281,637. Is that right?
Correct.
And then if you look then at line 10, you're showing a total combined incremental revenue requirement under unconsolidated rates of $1,255,867. Is that right?
Correct.
Is the reason for this discrepancy due to the typo on your surrebuttal exhibit MRR4 we previously discussed?
Well, it would increase it by, it would change it by $20,000.
Okay.
But it still wouldn't tie. There's still a certain amount of breakage.
Thank you, Mr. Riley. All right, changing topics here. I'm going to, similar to some of my live rejoinder before, I'm going to ask about confidential testimony, but I'm going to do it in a way to avoid having to go into confidential session. Just wanted to point that out. So, Mr. Riley, turning to the confidential version of your surrebuttal testimony on page 2, lines 20 and 21, you state that, or let me give you a second to find that there.
Page 2, lines what?
20 and 21. Is it correct that you state there that the deferred compensation amounts are not applicable to the current case because they were paid out on April 15th, 2021? Is that right?
That's correct.
Mr. Riley, did you hear Mr. Schellinger's testimony earlier about his typo on rebuttal exhibit MPS 2?
Yes, he said it should have been April 15th, 2023.
So given that correction today, that should have read April 15th, 2023, would you agree that the deferred compensation amounts are applicable to the current case and therefore should be included?
In part. One of the issues is the deferred compensation amounts contain deferred compensations for people that no longer work at MWS. In Mr. Sellinger's testimony, he indicated that 2 people have been switched out. Well, in his table, he still listed the names of the old people in there with their compensation in MPS 2-2 of 3.
But for that, your position is now with that correction that that should be included.
Some of it should be included,
Okay.
not all of it.
Thank you for that, Mr. Riley. Moving to a new line of questions here. Please refer to page 2, lines 7 through 12 of your SIR rebuttal. Do you have that in front of you? It is page 2, lines 7 through 12.
I'll read that first. Yes, I read it.
So you testify here that MWS should be allowed to recover incurred rate case expenses no later than the day before the evidentiary hearings begin in this case. Is that correct?
Correct.
Have you had an opportunity to review the updated rate case expense submitted by the company on September 23rd, 2024?
I'm still in the process of completing that.
Do you have a copy of that filing in front of you?
No.
Your Honor, I have copies that I can distribute it to everybody if it is useful, but also just for the witness.
I would assume everybody has
Okay.
it, but
Okay, thank you.
Could staff get a copy?
no, I assumed wrong.
So is it true that, as stated on this accounting, that the company's total incurred rate case expense up through September 23rd, 2024 is $218,610.15?
Well, that's according to your schedule, yes.
Okay. And would it be consistent with your position and testimony to allow the company to recover these costs?
No, because our position is under rate case expenses, we don't agree that the full amount that's paid to lawyers should be billed based on our testimony. My testimony supports a different hourly rate, and I haven't recalculated that
Right.
at the moment.
We'll get to that in a moment, but I guess is it fair to say with that adjustment, it's staff's position that these costs, again, adjusted, consistent with your position on legal fees, should be recovered in this case?
Well, unless it's invoiced, I'm not going to recommend recovery of the cost. Like you have under bill and process, I'd actually have an invoice for the top 3. I'd recommend that. But I wouldn't recommend reimbursing travel.
Have you reviewed the company's response to staff's data request and the supplemental response submitted yesterday at the associated invoices?
I've read it. I don't have it with me at the moment.
Okay, all right. Turning to your testimony regarding legal fees. Please turn to page 4, line 6 I'm going to ask about page 4, line 6 through page 5, line 18. Are you able to identify that?
Excuse me, is this the SIR rebuttal?
Of the SIR rebuttal. Yep.
Thank you.
I'm sorry, can I have
Okay,
that
I'm
one
on
page?
SIR rebuttal
okay.
testimony. What
Page
line?
4, you said?
Page 4, line 6 through page 5, line 18. Is it correct that you testify here, Mr. Riley? Your testimony cites to the rates included the local rules of the U.S. District Court of Maryland as the basis to adjust the hourly rates of legal counsel. Is that right?
Yes, we indicated we used a placeholder of $450 an hour. I did not make any computations based on the lines 14 through 22 because I didn't have any information on their period of service, how long they've had a law degree. So I couldn't computate those. But you have provided that to me in a subsequent filing.
Mr. Riley, when are you going to provide that information? Because we're at the evidentiary hearing today.
Well, you didn't provide the listing of how long the people were in their positions till yesterday. Correct?
That is not correct.
What day did you provide it?
We-
All right, this is not a question.
I know, this is
you're
not a-
not, you're answering. You're not asking questions, okay? Go ahead, try again.
Did staff counsel forward to you our response to staff data request? I guess it wasn't numbered, but staff's data request related to rate case expense that we submitted to staff on September 20th.
Okay, that was forwarded to me. Yes.
And did that include, in that response, the amount of time that the counsel involved in this case have been admitted to the bar?
I don't have that response in front of me. Can you provide it? I believe so, but can you provide it?
All right, let's revisit that in a moment.
Okay.
Let's actually return to your SIR rebuttal testimony and your position related to U.S. District Court rules. Is it correct that in your SIR rebuttal testimony, you specifically cite to page 127 of the U.S. District Court rules as support for your position? Is that right?
That's stated on lines 11 through 13, correct.
And it's your position that these rules serve as a, quote, useful guide?
Correct.
Do you know how these rates were adopted by the U.S. District Court for the District of Maryland?
No, I do not.
I have an exhibit to distribute. If I could approach.
You may. This will be applicant exhibit 24 for identification.
Mr. Riley, what is this document?
It identifies itself as Appendix B, and the bottom of the page says U.S. District Court of Maryland Local Rules, July 1, 2023, page 127.
With that, Your Honor, I request to move this document into evidence.
Any objections?
No objections.
All right. Mr. Tibbetts, any objection? Mr. Tibbetts, do you hear me? Any objections,
sir.
sir? Okay.
No, sir, none,
All right.
none, thank
All
you.
right. 24 is admitted.
Mr. Riley, do you see in the footnote at the bottom of the page that the rules state that the included rates are, quote, intended solely to provide practical guidance to lawyers and judges from requesting, challenging, and awarding fees?
Yes, I see that sentence.
Do you also see where it notes that, quote, the court recognizes that there are attorneys for whom and cases for which the market rate differs from these guideline rates?
Yes, I see that statement.
Is it your position that the commission is required to adhere to these rules?
It's not our position that they're required to adhere to this rule. Ultimately, the judge makes the ruling.
Excuse me, could you repeat the question and the answer? I was unintelligible.
Go ahead, sir.
My previous question is, or was, do you know if the commission is required to adhere to these rules?
No,
So I still can't. I can hear up through is required to.
Do you know if the commission is required to adhere to the local rules of the U.S. District Court of Maryland?
no, I do not.
Okay, but assuming that the commission were to look at these rules for guidance, doesn't the language we just reviewed suggest the commission should look at the kind of attorneys and case involved, as well as the specific market that they are operating in?
It does have a statement, the court recognizes there are attorneys for whom and cases for which the market rate differs from these guideline rates. That's a blanket statement, the next to last sentence in the footnote.
Would you agree that legal practice before the Maryland Public Service Commission is a specialized area of law, just based off of your work at the commission and seeing what happens here?
I'm not a lawyer, I can't comment.
Do you think any attorney could show up at the commission and represent a client in a case such as a rate case or any of the other numerous complex matters that the commission considers?
Your Honor, objection. I mean, the witness has already said he can't speak for what the standard should be for what the specialty of law practice or anything
I'll
like
sustain
that.
it. You can try again, different way. But he can't testify to. There may be some lawyer out there that comes in, hits the ground running, and can do a great job. But I don't think Mr. Riley can testify to that.
Okay. Do you have any factual support to suggest that the rates you cite to from the local rules of the U.S. District Court of Maryland are representative of the rates paid to lawyers that practice before the Maryland Public Service Commission?
No, I cannot. I've reviewed other rates, but I haven't done any extensive study to compare your rates to anybody else's.
So you've considered the complexity and specialized nature of utility rate cases when evaluating the reasonableness of the company's incurred legal expenses?
That's ultimately his decision.
Well, I'm asking you, did you consider the nature of this case when making your recommendation related to the adjustment of legal expenses in this case?
I haven't really thought about it. I was planning on using the guidelines.
Mr. Riley, you participate in many different commission proceedings, I assume. And is it true to say that you typically see the same half dozen private attorneys show up on behalf of clients at the commission?
Well, generally speaking, most companies keep the same outside attorneys, yes.
And many of the lawyers you often see in these cases are from larger international law firms, big law firms. Like, I think maybe the firms Venable and DLA Piper may ring a bell, maybe from, you look at filings and the cover letters. Any of those firms ring a bell to you?
Yes, I've heard of Venerable, but I've never done any research on the firm.
Okay. I have another exhibit to distribute here. If I may approach.
You may. This will be applicant 25. For identification.
this was coming.
Mr. Riley, what is this document?
This document is a cover sheet for the rebuttal testimony exhibits of Tanika R. Alexander on behalf of the Public Service Commission for the matter of the application of Chesapeake Utilities, Sandpiper, Inc., and Elkton Gas Company for a general increase in their natural gas rates and for the approval of certain other changes to their natural gas tariffs. Case number 9722.
And are there pages attached to that?
Yes.
The pages 9 and 10?
Yes, you have attached pages 9 and 10.
Thank you, Mr. Riley. With that, I request to move this exhibit into evidence as applicant exhibit 25.
The only concern is that we're just getting a piece of the testimony. I would just ask, I guess, that if we go pull up this testimony and we find relevant information on page 7 or 8, we not be precluded. Yeah, it won't be in the record. And my concern is that that could lead, I trust my colleagues from the utility, but I'm reluctant to allow in 2 pages of a document.
To the extent you believe you need to supplement this, I will allow it.
Thank you, Your Honor.
Any other objections?
None.
All right.
None, Your Honor.
Thank you. 25 is admitted.
Thank you, Your Honor. Mr. Riley, turning to page 10 of this rebuttal testimony from the Chesapeake rate case,
Okay.
looking at lines 4 through 5, do you see where it indicates the utility in that case was represented by both Venable LLP and Baker Hosletter?
4 through what?
4 through 5 on page 10. I think it's more correct
Yes.
to say 4 through 6.
4 through 6. Yeah, I see 2 separate law firms, Venerable LLP and Baker Hostetler, along with in-house legal counsel.
Thank you. And then moving down the page on line 12, do you see where staff indicates outside legal costs in the Chesapeake case at that time had accrued to $301,938?
Yes.
And do you see where this was in addition to $79,000 incurred by in-house legal staff?
Correct. That's line 12 and 13.
So is it correct that the total legal fees incurred until that point in that case totaled $380,938?
Yes, it appears to be $380,938.
And you're aware that the Chesapeake case, or are you aware that the Chesapeake case, maybe it had some wrinkles, but eventually it settled, it was never fully litigated?
I don't know if it's settled yet.
Okay, that's fine. Okay, Mr. Riley, looking back at the accounting of legal expenses that we previously talked about.
Are we done with 25?
Yes. Yep. Looking at this accounting, and I'm going to ask you to do some math, so I don't know if you're going to have to pull out a calculator, but is it correct that the total of all legal expenses incurred in this case as of September 23rd, in this case, was $130,170.49?
Is that different than this sheet you handed me?
I'm talking about legal expenses. That's my math. And I assumed you would have looked at this before the hearing, so I apologize for making you do the calculation now.
But we're talking about the attorney's fees.
Only the attorney's fees, so the invoices from Gordon Feinblatt.
Okay.
Okay. You said it totals what?
According to my math, it's $130,170.49.
130,000, what's the,
170 and 49 cents.
okay.
So 130, 170, 49 cents. Is that correct, or could you
Well, that's
accept
subject
that
to check.
subject to check? Okay. Could one explanation for the difference in legal fees in this case versus the Chesapeake case be the hourly rates charged by the large firms you often see practicing at the commission versus the rates charged by counsel in this case?
Well, I didn't review the rates that were charged by the lawyers in the Chesapeake case, so I can't comment.
I have one more exhibit to distribute, and then that's it. If I could approach.
You may. This will be applicant exhibit 26 for identification.
Mr. Riley, what is this document that you're reading through right now?
It says New York Law Journal, what $1,000 an hour gets you an AM Law 200 today.
Your Honor, I request to move this document into evidence as applicant exhibit 26.
Objections?
No.
And
How's he supposed to, you haven't authenticated this. Is there any foundation you can lay for this? I mean, you just printed an article out of off the internet. Looks like this morning. Have you ever seen this?
No, I've never seen this article.
Okay.
Well, I mean, it's a Bloomberg law article about legal rates charged by attorneys that
Is it specific to utilities?
it's not specific to utilities, Your Honor.
I mean, there's no foundation. And I was, yeah, I mean, I'm not going to let this in. I mean, unless anybody else wants to support it. But, I mean, he's never seen it. I mean, you just printed something off the internet, sir. I'm not going to, I'm not going to admit it.
Okay. Mr. Riley, am I correct to assume that it's standard practice for staff to request similar rate case expense data, including invoices from legal counsel, in all rate case proceedings before the commission?
Yes, yes, we do request invoices, correct, for rate case expenses. For all the ones I've been involved in, yes.
And based off this
excuse me,
action,
could you repeat the question and the answer, please?
You just need to come a little bit closer. Go ahead, Mr. Bugans, could you restate that, please?
okay. Am I right to assume that it is standard practice for staff to request similar rate case expense data to what staff has requested in this case, including invoices from legal counsel, in all rate case proceedings that involve outside counsel?
Yes, I have requested them in the cases I've been involved in.
So staff has actual data of legal fees, I'm assuming rates charged because you have the invoices of the attorneys that you've collected through discovery. Is that correct?
We have yes, we have some of the invoices, correct.
So has staff attempted to use any of this data to conduct an actual analysis of hourly rates charged by law firms you see practicing utility law in front of the commission? Or no? Has staff
No,
not done
we
that
have not
analysis?
performed that analysis.
So staff hasn't attempted to compare the legal invoices and rates in this case to the legal invoices and rates in other cases where staff conducted similar discovery.
That's correct.
And again, it's also true that staff has not conducted, even moving beyond practitioners before this commission, staff hasn't conducted any analysis of how the rates of the lawyers in this case compare to the rates of other lawyers that participate in the legal market in this region.
That's correct. We have not done any analysis.
Based off this discussion we just had, do you still believe you provided the commission with sufficient relevant data to adjust legal fees in this case without modification as stated in the local rules of the U.S. District Court of Maryland?
Yes.
And why is that?
We provided the criteria that's used by the U.S. District Court of Maryland local rules.
But don't those rules also suggest that the commission, or I guess speaking to the district court, but if they were used here, the commission should also consider relevant facts related to the kind of case, the kind of lawyers, and the overall market? Didn't we just review that language?
It does say the court recognizes there are attorneys for whom the cases which the market rate differs from these guideline rates.
Okay. I have two more questions, I promise. Related but slightly different. You recommend, Mr. Riley, limiting rate case expenses to actual costs incurred up to the day before the evidentiary hearing. Is that right?
Correct. That's our standard practice.
Are you aware, or what do you think about that? Are you aware that there are significant expenses, rate case expenses that are incurred during and after the evidentiary hearing, such as costs for post-hearing briefs, reply briefs, and appeals of proposed orders?
Yes, there are significant costs that occur after the hearing starts.
Thank you, Mr. Riley. Your Honor, I have no additional cross-examination. I am concerned about the company's response to staff's data request. We did provide the response on the 20th. We provided a supplemental response on the 23rd. It seems to me that staff intends to update its analysis or provide some kind of evidentiary basis regarding legal fees. And it was difficult to sort that out in cross-examination, but I want to raise that issue and see if there's a way we can make sure that information is provided.
We'll get there. Mr. Miller?
OPC has no questions, Your Honor.
All right. Mr. Tibbetts?
No questions, Your Honor.
Mr. Albert?
Just a couple follow-up. Long discussion about these U.S. court rules and the guidelines they give. Does this give you sort of an objective standard that maybe that staff has not really had access to previously in terms of its recommendation on legal fees? I mean, is there a benefit of having a government entity coming forth and saying, we think these are reasonable hourly fees?
Yes, there is a benefit for a government entity providing guidelines of reasonable fees.
And what is that benefit?
Well, it benefits the customers that they're not paying for excessively high legal rates.
And there's been a lot of...
Were you done, sir?
Yes.
Okay.
Sorry. And there's been a lot of discussion about what was paid in other rate cases here by utilities to the lawyers. Is that information that you find persuasive on what the appropriate hourly cap is, that is data charged by other lawyers in other rate cases? You view that as relevant to your review?
Well, there is the complexity of the rate case should have some impact, yes.
But you have not, staff has not done any kind of analysis.
No,
like
we
that.
have not performed any analysis.
You relied on the U.S. court rules here as something that would be a standard that's out there that can be relied on.
Correct.
Nothing further from staff.
Afternoon, sir.
Okay.
Is this the first time you've relied on the federal rules?
Yes, this is the first time we've relied on federal rules.
And not that Mr. Bugelman's was prompting me, but I had this question anyway. You'd said you're still reviewing the company's attorney's fees up until, I guess, the 20th or today. Is that correct?
Up until yesterday.
Up until yesterday, okay. When do you envision being finished with that review?
Thursday at the latest. We may have to contact them if we're missing any invoices.
All right, well, I think that pretty much guarantees that we're going to be back on Friday, at least briefly. I believe OPC recommended a 3-year amortization period. Is that something you support?
Yes, they had yes.
Okay, all right. If I could get you to turn to your rebuttal, sir. Or, I'm sorry, sir rebuttal.
Sir
My
rebuttal,
apologies.
okay.
Page 6.
All right, just hold on a minute. Okay, I'm on page 6.
All right. Interested in the question and answer that starts at line 9 and continues to line 18. And I recognize there's that first or second sentence, I should say, is confidential. In terms of the discrepancy between the confidential and non-confidential, is that just, in your mind, is that just, the company updated its figures in rebuttal testimony, and you're taking the lower one as correct?
Well, the issue is what they filed in their non-confidential testimony as Exhibit MPS 6 does not match up to what they filed in their confidential testimony. Their confidential testimony had a smaller dollar amount for wages and salaries than MPS 6 did.
Okay.
They should match.
Understood. Okay.
They should match.
Sure. Obviously, you took the lower one?
Correct.
Okay. All right.
The confidential was the lower amount.
Right. All right. Covered attorney's fee. If I could get you to turn to the next page, sir. And this answer is all confidential. Is there, you were here for the company's testimony on this issue, correct, this morning?
I was here this morning.
Okay. All right. And I believe they indicated that you may have double count, their opinion that you may have double counted.
Are you regarding overtime or are you incentive pay?
I'm sorry, it was the incentive pay. I think that's. Oh, no, I'm sorry. Yeah, you're correct.
Yes. There is a possibility I did. It would have overcounted if I accepted all their charges from 4/15/2023 as correct.
Okay. All right. So I have a couple questions. While you're updating your attorney's fees calculations, do you intend to?
We will give you a new revenue requirement based on that.
Based on in the typographical error that was.
Yes.
Okay. All right. Good. All right. So I'm sorry. On page 7, I believe the company witness indicated that this was an isolated adjustment. I think that's the term I had written down. Do you have any response?
No, it's not an isolated adjustment because they made an adjustment in April to increase salaries 3%. So if all their pro forma adjustments were after the end of 12/31, using that interpretation, quite a few of those would fall under isolated adjustments.
All right. I think that's all I have for Mr. Riley. Any follow-up based on my questions? Mr. Albert?
No, Your Honor.
Mr. Miller?
No.
And that was a no for you, Mr. Tibbetts?
That was no, yes, sir.
Okay, excellent. All right. Guess we'll look forward to the update.
Okay. Thank you.
Appreciate it, sir. I assume that addresses your concern, Mr. or
I was concerned that the information didn't get to the witness, and
Right.
I wanted to make sure we have a
well,
complete
I
record.
don't have any
You don't have anything to do with that.
on the data requests yet, so we'll just look forward to staff's update on Thursday, and we'll plan on reconvening on Friday anyway. So, Mr. Albert.
Your Honor, our last live witness is Ms. Barbara Weber.
Okay. Does anybody have any cross for Ms. Weber?
My understanding is that you said you might have questions. I could be
No,
wrong.
I asked all my questions the other day, but don't go anywhere. Just you're here. So, Mr. Bugelmans, do you have anything for Ms. Weber?
I have no questions.
Mr. Miller? Mr. Tibbetts, do you have anything for Ms. Weber?
No, sir.
Yeah, no. You were good to go, Ms. Weber. I mean, you can stay if you like. All right, very good. All right.
Okay. No, defer to my co-counsel.
I'll take it from here, Your Honor. Staff calls Eric Granum to the stand.
All right. Sir, can I get you to raise your right hand? You swear or affirm under the penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir. Can you please state your name and spell it?
Eric Granum, Erikgranum.
All right, thank you, sir. And can you provide your business address, please, sir?
Yes, 169 East Wisconsin Avenue, Suite R, Oconomowoc, Wisconsin, 53066.
All right, thank you. Mr. Greger?
This witness is available for cross.
Okay, no changes. All right.
Thank you,
Mr.
Your Honor.
Bugelmans.
Mr. Granum, nice to speak with you. My first question is related to page 3 of your SIR rebuttal. Do you have that in front of you?
I'm sorry, my sir rebuttal?
Correct. Page 3 of your SIR rebuttal testimony.
Yes.
So just to make clear, lines 12 through 13 of your SIR rebuttal on page 3, you state that you do not object to company witnesses Miller's method for allocating purchase water costs. Is that right?
Yes, based on the context in lines 10 and 11 and testing the impact of changing the allocation methodology, I found the difference to be negligible.
Thank you for that. Mr. Granum, moving down on page 3, starting on line 16, is it correct that you continue to oppose company witness Miller's proposal to allocate 100% of overhead corporate allocation costs to the billing and collection function?
Yes, that's correct.
Did you perform a detailed analysis of the specific components within the overhead corporate allocation to determine the exact percentage attributable to billing and collection?
I reviewed the confidential document that was discussed during witness Miller's testimony. Based on that review, it appeared that in 2021 dollars, the amount of customer billing related expenses in proportion to the total corporate overhead was about 22%. I estimated that could be in any given year in a range between 20 and 25%. And so I updated my allocation to include a reasonable estimate of 25% of that cost.
Mr. Granum, I know you were virtual, but I'm assuming you're able to hear. Did you hear Judge McLean's questions to company witness Miller this morning about the age of the 2021 corporate services report, which was entered into evidence as staff confidential exhibit 12?
Yes, I heard the questions. I don't know if I can absolutely recall them word for word.
It was devastating. Devastating cross. No, go ahead, Mr. Bugle.
Well, just to refresh your, well, do you recall that the discussion was effectively, since 2021, the water economy, we've seen inflationary pressures. So the conclusion was effectively the cost in the 2021 report would likely be higher today as a result of those pressures. Do you recall that?
Yes, I recall that.
Do you agree with that conclusion?
No, the inflationary costs, I imagine, would apply to all overhead corporate costs. So the key is the proportion of costs that are related to customer billing and collection.
Thank you, Mr. Granum. A couple more questions here. Turning to page 5 of your Sir rebuttal testimony, you able to pull that up?
Yes.
Lines 12 through 16, your Sir rebuttal. Is it correct that here you recommend that the company prepare and file a sewer cost of service study in the next rate case proceeding?
Yes, I would recommend that.
Would you agree that preparing a cost of service study involves significant effort and expense for the company?
No, I would not think it would be considered significant.
What's your basis for that conclusion?
The total amount of the cost that it would take to prepare a cost of service in relation to the overall cost of running the sewer utility.
Isn't it correct that the cost of preparing that study would be a rate case expense that could be collected from customers in the next rate case?
I'm sorry, could you repeat that? I didn't quite catch that question.
Is it correct that the cost of preparing a cost service study for sewer, that is an expense that could be recovered from customers as a rate case expense if the company is required to do so?
I did not prepare anything regarding the revenue requirements in this case. My testimony is solely focused on the cost of service and the allocation methodology.
Okay.
So I couldn't say.
Okay. All right. I have no further questions.
OPC? Mr. Tibbetts?
No further questions.
All right. Mr. Greger, anything?
No, Your Honor.
Sir, do you think with the cost of the sewer cost of service study, why do you think that would be a useful, I don't want to say call it exercise, why would that be useful to the company, to the commission in the next rate case?
It would help the commission and staff and everyone understand the cost structure of the sewer utility, in particular, how much cost should be recovered through the fixed charge versus the sewer volumetric rate. And the cost of service would guide that, would help determine what that balance is.
Okay, and you state that it's unclear how the rates were ultimately set compared to the cost of service study that was prepared in this case. Is that
in the previous case?
In the previous case, okay. Because there was no cost of service study for the sewer in that case either?
There was, but I don't believe we found enough information in the record to confirm how the rates were set based on the cost of service,
right,
based on the information we were provided.
Okay. Generally, is it, in rate cases generally, is it always preferable to have a cost of service study?
Generally, yes.
Okay. All right. Any follow-ups based on mine?
No, Your Honor.
None, Your Honor.
All right. Thank you very much for being here, sir. I appreciate it.
Thank you. I appreciate Your Honor.
Thank you, Your Honor. Staff calls Christine DeMaster to the stand.
How you doing, ma'am? Can I get you to raise your right hand? Do you swear or affirm under the penalties of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, ma'am. Can you please state and spell your name, please?
Christine DeMaster, Chrisistine, DEMASTER,
And what's your business address, ma'am?
169 East Wisconsin Avenue, Suite R, Oconomowoc, Wisconsin, 53066.
All right. Thank you very much.
Thank
Mr.
you.
Squirter.
To clarify, Ms. DeMaster, you filed direct and surrebuttal testimony in this case. Is that accurate?
Yes.
Do you have any corrections to make to either of those two pieces of testimony?
I have a couple of corrections to make to my rebuttal testimony. On page 6, lines 1 through 3, I stated that I revised public fire protection rates to exclude the number of meters served by Highland Estates and Lakeside Vista, as those two systems do not receive public fire protection service. So that statement is still accurate. However, MWS initially provided an equivalent meter count of 81 meters for Lakeside Vista to exclude from that calculation. After I filed rebuttal, it was discovered that that should have been multiplied by 12 to have the appropriate number of building units, or 972 equivalent meters to be excluded. So that would change slightly the public fire protection rates shown in my testimony on page 15 in table 4, from $3.95 for a 5/8 inch meter to $4.04, so an increase of 9 cents. And that same change would have to be made on page, table 7 on page 20 of my testimony.
And can you repeat those corrections to those tables again one more time for the group so we can?
Okay, so that would be
accurately-
table 4 on page 15. The public fire protection rate would go from $3.95 to $4.04. And then you would see the same change on table 7 on page 20.
Thank you. And were there any additional corrections?
No.
Thank you. Your Honor, this witness is available for
All right, thank
cross-examination.
you. Mr. Bugans.
Thank you, Your Honor. Mr. Master, nice to see you again. Is it correct that your position and your pre-filed testimony throughout this case, including your rebuttal, has been that the company should eliminate its UFW surcharge reporting and reconciliation process for Pinto and Highland Estates?
Yes, if my position has been that if the rates are consolidated for these 4 systems, that the purchased water pass-through rate and the unaccounted for water surcharge should be eliminated to avoid charging Pinto and Highland customers for a portion of the water supply cost for provinces and Greenridge systems, and also requiring them to bear 100% of the cost of their own water supplies through that separate rate.
Thank you for that. So is it correct that now that Judge McLean has rejected rate consolidation by rejecting the settlement, does the specific justification that you provided to remove the UFW surcharge reporting and reconciliation process, is it true that that justification would no longer exist with unconsolidated rates?
Yes, if the commission were to decide to adopt or approve unconsolidated rates, my rationale for eliminating the purchased water pass-through and unaccounted for water surcharge would no longer be a concern. So I would support keeping those mechanisms on the tariff in that event.
Thank you. Have you reviewed the updated rate design workbook prepared by the company and submitted as a supplemental response to bench DRs 1.1 and 1.2 on September 20th?
I was not on the initial list for that. I did receive that at 12:59 p.m. today. I took, and I have it, let's see here. I did take a quick look. I had a couple of minutes to look at the average bill, monthly bill comparison sheet. I have not had an opportunity to look at the underlying rate calculations. The numbers I'm seeing here do look to be about what I would expect for unconsolidated rates.
Thanks for that. I'm going to ask some very basic questions, and recognizing that you haven't had much time to review, we'll see if you can answer them. The revised workbooks continue to propose to recover 38% of water revenues from fixed charges and public fire protection charges. Is it true that you previously supported such an allocation?
Yes, I did support that allocation in the my testimony in support of the settlement.
Do you still believe such an allocation is reasonable?
Yes, I consider that to be reasonable.
Thank you. And further, the revised workbooks also continue to propose to recover 40% of sewer revenues from fixed charges. Is it also true that you previously supported such an allocation?
Is there a question? Sorry.
Sorry, maybe I'm mumbling a little bit. Just to repeat my question, the revised workbooks that you received today also continue to propose recovering 40% of sewer revenues from fixed charges. Is it correct that you previously supported such an allocation?
Yes, I did support that in my testimony in support of the settlement.
And do you still believe such an allocation is reasonable?
Yes.
Thank you, Mr. Master. I have no further questions, Your Honor.
All right, thank you. OPC? No questions. Mr. Tibbetts?
No further questions.
Mr. Greger?
No redirect, Your Honor.
Thank you very much, ma'am. I have no questions. All right. So that's everybody today?
That is, yes, Your Honor, for staff.
Okay. And OPC. All right. Mr. Miller, are you able to express OPC's position on attorney's fees and the new, I guess, the proposed rate design from the company?
Not alone, Your Honor. I would need my witnesses to.
Okay. Well, then they'll need to be here.
Those two, the Mr. Morgan and Mr. Mears, well, correct?
Yes. I don't believe anyone has any ROE issues. So why don't we plan on being virtual on Friday? 10 o'clock work for your witnesses, Mr. Miller?
It should, Your Honor. I will confirm, but yeah,
And
it should.
I assume it'll work for staff as well, Mr. Greger?
Yes, just to clarify, we are recalling Mr. Riley?
Yes.
Yes, Your Honor.
Okay. Mr. Bugelman's anything else?
I think that's it for today, Your Honor.
All right. While we got everybody here, let's talk the rest of the time here. Briefing. I'm going to go out on a limb and say that you guys probably want more time than I'm willing to give. All right. So we'll finish up on the 27th, but I would imagine it would be quick. How does the 4th look for initial briefs, or for briefs? And I'm trying to give the commission as much time as possible with this.
Your Honor, is the concept that would be initial briefs, we have a later date for reply briefs, or would that be a single?
We did not have reply briefs in the original schedule, and I don't think we have the time to do it now, unless we want to, unless the company wants to kick the can down the road a little bit. And I know you're obviously under no obligation to do that, but given the time frame we have, I just don't.
I understand that, and the company would be fine with one brief.
Okay.
The reason why I was asking was I was thinking we could maybe push the date a little bit further down to the month if you want to reply and just do one round, but it doesn't seem like you're thinking of that. I mean, is there any additional flexibility maybe for that Monday or Tuesday?
I mean, I could live with Monday.
Okay.
I could live with Monday, October 7th. And I would try to get my order out as quickly as possible.
Yep.
And I do plan on shortening the appeal time for the parties, not necessarily the commission's review time, though.
Yep.
Staff has no objection to October 7th, Your Honor.
Mr. Miller?
If that's what it takes, Your Honor.
Excellent. Mr. Tibbetts?
That's fine, Your Honor. Can I have a chance to lay an objection on the record just so I don't have to do it later?
Sure, go. What's your concern, sir?
Okay, well, my objection goes back to the first hearing where you refused to allow evidence about the EPA standards. I want to object to that. It's a continuing objection. So that way to basis for appeal.
It's already on the record. You objected to it, and I overruled it. So it is what it is at this point. All right.
Sure.
So the 7th for briefs, and like I said, I'm gonna shorten the appeal period. So it's going to be a quick turnaround for if anyone wants to appeal. Okay.
I was just chatting, nothing further.
Okay. All right. Anything else? Mr. Tibbetts, anything else, sir?
No, sir.
All right. We are off the record. Thank you, everyone.
Thank you.
Yeah.